In 3 days, on January 20th, the Supreme Court of the United States is going to hear oral arguments in a case that will fundamentally reshape concealed carry rights across America. And if you own a firearm or plan to carry one, you need to understand exactly what's at stake because this ruling will determine whether you can legally carry your gun on private property or whether the government can effectively ban you from every shopping center, restaurant, parking lot, and business storefront in your state. The case is called Wolford v. Lopez, and it centers on Hawaii's concealed carry law, specifically a rule that sounds simple on the surface but has massive implications. Here's how it works right now in Hawaii. If you have a concealed carry permit, which requires background checks, training, and approval from the chief of police, you can technically carry your gun. But there's a catch. Hawaii's law says you cannot carry that firearm on private property unless you have express written permission from the property owner. Not implied permission, not assumed permission, express permission. That's the default rule. Firearms are prohibited everywhere unless someone explicitly says you can bring them. This might seem like a reasonable regulation until you understand what it actually means in practice. In Hawaii, where the state is made up of islands and commercial zones are concentrated, a permit holder effectively cannot exercise their carry rights anywhere public life happens. You can't carry in a restaurant. You can't carry in a shopping mall. You can't carry in a grocery store parking lot. You can't carry at a gas station. The property owner has to actively post a sign saying firearms are permitted, which virtually no business owner does. So, in effect, Hawaii's default rule makes it virtually impossible for someone with a valid concealed carry permit to actually use that permit in their daily life. That's the core of the constitutional issue. The case started when three Hawaii residents with concealed carry permits, Jason Wolford, Allison Wolford, and Adam Kasperzicki, along with the Hawaii Firearms Coalition, sued in federal court. They said this law violates the Second Amendment. They argued that in 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruen, which established that the government can only regulate firearms based on historical precedent. And they contended there was no historical tradition in America of states imposing a default ban on carrying firearms on private property open to the public. The lower federal court partially agreed and blocked some provisions of Hawaii's law. But then the Ninth Circuit Court of Appeals, which covers Hawaii and the West Coast, stepped in and mostly upheld Hawaii's restrictions. The Ninth Circuit said states do have a historical tradition of requiring permission from property owners before carrying weapons on their land. They cited an 1865 Louisiana statute related to plantation property and an 1771 New Jersey hunting regulation as historical precedents supporting Hawaii's rule. But Wolford's attorneys argue these historical examples don't actually support Hawaii's law. The 1865 Louisiana statute, they point out, was part of the Black Code specifically designed to disarm newly freed Black citizens after the Civil War, making it a discriminatory law enacted for oppression, not neutral property protection. And the 1771 New Jersey statute was about hunting on closed private land, not carrying firearms on commercial property open to the public. The plaintiffs argue Hawaii is using weak historical analogs to support a modern regulation that simply doesn't have real historical roots, which violates the Bruen standard. The constitutional question before the Supreme Court on January 20th is this: does the Second Amendment's protection of the right to bear arms apply on private property that is open to the public? And specifically, can Hawaii presume that carrying is prohibited on all private property unless the owner affirmatively consents? Or does the Second Amendment require a different default, where carrying is presumed to be permitted unless the property owner affirmatively prohibits it? This distinction matters enormously. Under Hawaii's current law, the burden is on you, the gun owner, to find evidence that a property owner allows carrying. Under the constitutional challenge being argued, the burden would shift to the property owner to affirmatively exclude guns. That's a complete reversal of the legal presumption. Here's why this matters beyond Hawaii. 4 other states have essentially identical laws. California, Maryland, New Jersey, and New York all have similar provisions requiring property owner permission to carry on private property. Plus, if the Supreme Court upholds the Bruen standard and applies it strictly to private property rules, it could affect dozens of other state and local regulations that make assumptions about where guns can be carried based on property ownership rather than historical tradition. The Supreme Court has a 6-3 conservative majority. 3 of the justices, including Chief Justice Roberts, have shown skepticism about regulations that functionally eliminate a constitutional right. Justice Kavanaugh, in his concurrence in the Bruen case, specifically expressed doubt about regulations that strip people of the ability to exercise their Second Amendment rights in ordinary public life. That suggests he might side with Wolford. The more liberal justices are likely to defer to Hawaii's property rights arguments, but they're outnumbered. Legal analysts predict the court is likely to narrow Hawaii's rule at minimum. The most probable outcome is that the court strikes down or substantially limits Hawaii's default ban, at least as it applies to private property open to the public. The court might rule that while property owners absolutely retain the right to exclude firearms from their premises, the state cannot impose that restriction as a default rule. Instead, property owners would need to affirmatively prohibit firearms, not the other way around. What happens next after oral arguments on January 20th? The justices will meet in conference behind closed doors, likely on Friday of that week. They'll discuss the case and take preliminary votes. One justice will be assigned to write the majority opinion. Others might write concurring or dissenting opinions. Then the entire opinion is circulated, revised, and debated among the justices. This process typically takes months. The Supreme Court's term runs until June, so you should expect a decision sometime in late May or June of 2026. When that decision comes down, it will instantly trigger legal challenges to the concealed carry laws in California, Maryland, New Jersey, and New York. The decision will also likely influence dozens of lower court cases nationwide challenging similar regulations, and gun rights organizations are already preparing follow-up cases to challenge other restrictions based on whatever reasoning the Supreme Court uses in Wolford. For you personally, if you live in Hawaii or any of those other states with similar laws, this decision could change your legal rights immediately. You might suddenly have the right to carry in places where it's currently prohibited, or the decision could confirm that the government can maintain these restrictions, in which case your carry rights remain limited, but the ripple effects go far beyond those 5 states. The broader constitutional principle at stake is whether the Supreme Court's Bruen decision, which requires historical precedent for gun regulations, applies equally to private property rules as it does to other firearms restrictions. If the court says yes, it means dozens of state and local laws could face challenges. If the court narrows Bruen's application or finds historical support for property owner rules, it signals that the Second Amendment's protection has limits. This is why January 20th matters. This is why the next 5.5 months of waiting for the decision matter. And this is why every gun owner, whether you live in Hawaii or anywhere else in America, should be paying attention to what the Supreme Court says when it rules on Wolford versus Lopez. The decision will establish constitutional principles that reshape carry rights nationwide for potentially decades to come.